Hello everyone. Please confirm if you can hear me.
I can hear you.
Okay. Hello everyone. Good evening. Welcome to week 2 of our JIIPCC Data Protection and Privacy series. I am Ogonna Annette Onwudiegun, and I'll be your moderator for this session. Oh yes, good evening, best. I'm also an IP and data protection enthusiast, and of course, a JIIPCC alumni. I would love to welcome you for making it today's session, for making time out of your busy schedules. And if our moderators are here, sorry. Hi, Michael. Good evening. If our educators are here, just a minute. Okay, I would also love to welcome them to this session. This is the fourth cohort we are having this 2023. And I also love to use this opportunity, this medium, to tell you that we have our registration going for the next cohort. So it's a golden opportunity I don't think you should miss. You can share this to your family, to your friends, tell them that you've tapped from this gold mine and tell them that you would love them to also tap from it. And you can also register for other JIIPCC online courses. There are lots on the screen, so it's not just data privacy and protection. And then, okay, yes, we also have 30 minutes direct mentorship with any of your favorite JIIPCC mentor. In the course of these sessions you would have with JIIPCC, you would see a lot of them, a whole lot. So perhaps you have a lingering question or you just want a closer interaction with them. Reach out to any of the coordinators and yes, you would get hacks, secrets, life lessons, and direction from your favorite mentor. Okay, our first speaker for today's session is Mr. Emmanuel Ewere, and I'm going to start with reading out his profile. Mr. Emmanuel Ewere is an accomplished information technology law specialist with a wealth of experience in guiding clients through the intricate landscape of technology. With over 8 years of expertise in the field, he has been a trusted advisor on various legal matters related to information technology, including data privacy, cybersecurity, intellectual property, and e-commerce. Education has been a cornerstone of Emmanuel's professional journey. In 2015, he earned his called-back certificate from the Nigerian Law School, building a solid foundation in general law. He further honed his specialization in information technology law by pursuing a master's degree from the University of Tartu in Estonia. Prior to that, he completed his Bachelor of Law at Madonna University in Nigeria. Emmanuel's career has been marked by significant accomplishments, and he has held key roles in prestigious organizations. As a business developer at Flowworld LLC in the United Arab Emirates, he managed various projects ensuring compliance and due diligence. He provided crucial counsel to clients on matters such as data privacy, cybersecurity, and intellectual property. Additionally, Emmanuel's skills in drafting contracts, conducting market research, and budgeting were instrumental in driving the success of various projects. During his tenure at Adamson, Edeboro, SAN & Co., a prominent law firm in Nigeria, Emmanuel actively supported attorneys in legal research and document review. He played a pivotal role in drafting legal memos and reports, while also engaging in client meetings and negotiation. His litigation experience was an asset in court appearances on behalf of clients. Emmanuel Ewere is not just a legal expert, but also a tech-savvy professional. His technical skills include proficiency in Python and a comprehensive understanding of information technology systems and processes. He excels in risk management and compliance, crucial elements in the dynamic world of IT law. Moreover, his adeptness in contract drafting and negotiation, coupled with a solid grasp of cloud computing, Internet of Things, and blockchain makes him a well-rounded specialist in the field. Recognizing the importance of continuous learning, Emmanuel has pursued various professional development opportunities. He holds a certification as an information privacy professional and consistently engages in continuing legal education courses that focus on privacy and cybersecurity law. Emmanuel Ware actively contributes to the legal community through his affiliations. He's a member of the Nigerian Bar Association, where he actively collaborates with fellow professionals to address emerging legal issues in the tech world. Furthermore, he's a member of the International Association of Privacy Professionals, a testament to his commitment to staying at the forefront of data privacy matters. With his impressive credentials and extensive experience, Emmanuel Ware continues to make a significant impact in the realm of information technology law. Through his legal acumen and technical expertise, he serves as a reliable ally for clients seeking guidance in navigating the intricate legal challenges of the legal age. Thank you so much for for deciding to share your legal knowledge with us. This information technology knowledge is a very impressive CV we have. Mr. Solomon Okedara, barrister and solicitor of the Supreme Court of Nigeria, is a practicing legal practitioner and researcher with over 14 years post-core experience and outstanding experience in human rights with a special bias for digital rights, including data protection and privacy, digital identity, online expression, intellectual property, e-commerce, tech and corporate transactions, and artificial intelligence, having an unusual knack for excellence and matchless client satisfaction with a view to delivering maximal results. Armed with a peerless ability in creative legal research and analysis, delivering impressive results in review of laws, legal principles, and standards. Solomon is a partner at Solomon Okedara & Co., a firm of barristers and solicitors, and co-founded the Digital Rights Lawyers Initiative, a not-for-profit NGO that focuses on promotion and protection of digital rights. Solomon is a strategic litigation lawyer with a robust interest and proven expertise in freedom of expression and digital rights litigation. He has litigated on digital rights and freedom of expression subjects in courts across Nigeria up to the Supreme Court, and he has conducted cases at the OCOWAS Court, among others. Solomon was in 2020 recognized as one of the Solomon was in 2020 recognized as one of the top 50 individuals leading in legal innovation in Africa at the Africa Legal Innovation Awards. Solomon currently serves as the legal researcher at Columbia University in the city of New York for the Ivy League Skills Global Freedom of Expression Project, where he analyzes judgments bordering on freedom of expression, covering over 150 jurisdictions across the world, including the United States, Europe, India, and Africa, among others. He's a 2016 Research Fellowship recipient of International Center for Not-for-Profit Law, ICNL, Washington, D.C. He has specially he was specially recognized in 2017 Heroes of Human Rights by Access Now. Solomon was specially recognized as a finalist at the 2018 Global Freedom of Expression Prize of Columbia University. If this does not surprise you, I don't know what else does. I would like to use this opportunity to welcome our speakers. And while waiting, I think our mentees are going to go ahead with their presentation.
We can't hear you. I think you are muted.
Okay, it seems she's having a little bit of network issue. All right, before she comes back to continue with her moderation, can we have Group 1 and Group 2 come up with their presentation? Our mentors are not yet available, but they'll be joining us shortly. So you can come up and make your presentations before we get on with the rest of the class. Thank you. So Group 1, you can take the stage. You can come up and make your presentation.
Hello, can everyone hear me?
Yes, I can hear you.
Yes, we can hear you now. We're not hearing you some minutes ago.
Okay, it seems you are still muted. Group 1 and Group 2. Group 1, you can come up and make your presentation. We are waiting for you.
All right. Remy Gombo Saru for Group 1. Good evening, everyone, and welcome to this session. Can you see the screen, please?
Yes, we can see your screen.
Okay, thank you very much. So, for this week, we are looking processing, transfer, best practice level, reconciliation. And it shows that we're looking at three main things here: data collection, data processing, and data transfer, and all the other concepts that follow suit, which include data minimization. So I'll jump right in with data collection. Data collection now is gathering data, evaluating the information. And there are many reasons why people gather data, which is usually for forecast, prediction, or for research. And so we see that there are a lot of reasons why data is being collected. You see there are many ways to gather data, either on field or by drawing from other sources. So that's basically data collection, just getting the data. And one example I'll give is population data. Population data, where people go around to houses to get data. And that's basically what data collection is. But what applies to us now is data collection for personal data. We already discussed that. That's our main concept here, personal data. That is the data that relates to the individual. So I'm not going to go into all the other types of data. And for this act, we know we are governed by the Nigerian Data Protection Act and GDPR. And so it says here that the purpose limitation is what relates to data collection, that the collection of data, identifiable data of the data subject must be specified, clear, and of legitimate purpose. So people don't just collect data. What is the reason? That is, it must be clear and legitimate. That's Article 5, Sub 1B of GDPR and Section 21B of the Data Protection Act. And now we move on to data processing. When data has been collected, it's been processed. An example I'll give is in the past election, data was collected from the different polling units and it was collated down to the national level. You see that data was processed, but it has to be processed on a machine level, that's for the computer, not the one that humans can see and understand. That is the way the data moves. So the data is being processed. And because of the nature of it, that is data processing involves a very technical ability for the data to be processed. That's, I think, one of the reasons why it is so important and strict, because we don't want data to be lost along the way. And part of data processing we see is the introduction of third parties. Third parties also process data. We looked at that in our last class, where MTN can decide to get people to register SIMs on their behalf. Those are third parties, and they are also part of the data processing stream. And they are also governed and regulated. You know, it's between the contracts now, that is between them and the data entity, which is MTN in this scenario. Now, data transfer is the process of utilizing computing techniques to transmit or transfer data from one computer node to another. We've looked at data collection, data processing, and now data transfer. And it is very important because we just don't want data to be transferred anyhow. We want it to be governed according to the regulations. That's why the Data Protection Act applies to us. That's why the GDPR is there, and so many regulations. And it is a very strict thing because many times you've seen that organizations, corporations, they transfer data without your knowledge. They transfer data without consent, and it is very wrong. That's what we are going to look into now, data transfer, the transfer of data. So it says here, it must be, that is, third parties must be the one that has adequate level of data protection and must have functioning data regulation. That's if the data is collected and processed by third parties. And now we don't want data to be leaving our shores for what we don't know. I think recently Meta and DHL were summoned by the commission, as the Data Protection Commission, for violating certain rules regarding their collection of data. We look at all those things and see that maybe they are flouting a rule, a regulation which they should not do. So in Nigeria, transfer of data is regulated by the supervision of the Data Protection Act and the AG of the Federation. Also, here, as I said, some laws restrict the transfer of data outside their own jurisdictions. They are very strict with the data leaving. It is governed by regulation, and they don't want anybody to have unlawful access to data because it is very protected. And one of the things that we see in the protection of data is the development of best practices for data. It's more of a regulation thing. That is not compulsory that you must follow all of these best practices, but rather for the safekeeping of the data in your care, the safekeeping of the data that you want to process, you have to follow them. And it says here, which is number one now, which is compulsory, compliance with the data protection and privacy regulations. Look at the GDPR in the European Union and the Nigerian Data Protection Act, encrypting the data, installation of anti-malware software, establishing of data usage policies. All these things, this is not all, but these are what we call the best practices that will help you, your organization, that is data collector, data processor, for keeping the data properly. Now, the types of data, there are many types of data. So we have the public data. This is information that is free for everyone. You know, sometimes you go to the marketplace and you ask someone, what's your name? And they can't tell you, or they won't tell you because you don't have the right to know. That's private data. But now we are looking at public data. It is accessible to everyone, such as press publications, data that can be seen by the public and can be accessed by the public with no level of restriction. And we have personal data, as I said, your name is a personal data, email address, phone number, all these, they belong to you. as the data subject. And it doesn't really have a high level of security, it's more for identification. But since it is yours, you have the right to decide if it can be given out or not. As I said, the sensitivity level is medium. Internal data, which is for business or corporations or organizations, what they go through, what they want to publish to someone, that is internal data. And sensitive data, I think sensitive data was highlighted in the regulation.
Okay. If we can't, it seems we is having network issue.
As can you hear me?
Yes, we can hear you now.
Okay.
We stopped hearing you
Thank
for a
you.
while.
Sorry. Let me just-
Please go ahead.
Yes, I'm coming. Let me share the screen. Yes, so I stopped at confidential data, and as it says, the confidential data access might involve aspects of identity and authorization management, such as your vehicle identification number, SSN, credit card numbers, medical and health records. It is very high. That is the sensitivity level. And as we've been talking about sensitivity levels, these are the three classes of sensitivity levels in descending order: high sensitivity data, medium sensitivity data, and low sensitivity data. We look at their effect, which is if they are compromised, what is the damage done? Here, high sensitivity data has a catastrophic impact if it is leaked or compromised. Medium sensitivity data, not so much as high sensitivity data, and low sensitivity data, the ones for public use, it doesn't have much of an effect. And then the concept of data minimization is a core principle of data protection, and it involves the limitation of data only to that which is necessary. That is, it is for a specific purpose, and it is captured in Article 5(1) subsection C of the GDPR and Section 21 of the National Data Protection Act. And so the way it is described is personal data should be adequate, relevant, and limited to that which is necessary in relation to the purposes for which they are processed. That is data minimization. And so we looked at the way they defined what the data must be: adequate, relevant, and limited. This is what it means for the data to be minimized to what is necessary. Is this necessary? An example could be, let's say people that are working in Shell, they need to know the blood types if there's a health hazard. But for someone that is going for, let's say, receptionist duty, they don't need your blood type. So we see that is it adequate, is it limited, is it necessary? This is the definition of how data minimization is captured and defined by the Act. Thank you very much. That's it for group one. Thank you.
Thank you so much, Juan, for that insightful presentation. Even I learned enough, and kudos to your group. And next we would have is group 2. Are you ready with your presentation? And I'd like to also use this opportunity to encourage all of us to put on our video so that we can get to see each other, get to know each other. So we are sure we're not robots. Please turn on your video. Group 2, are you ready? We have 15 minutes for your presentation.
Good afternoon, everyone. Can you all hear me?
Good afternoon.
Yes, we can hear you.
Okay. Okay, so I'll be taking us on Group 2's presentation, which is the lawful basis for data processing, lawful data transfer, and international data transfer. So we'll be starting with an introduction.
Okay, we can't hear you, Mr. Presenter. Please, can you unmute yourself and continue with your presentation?
Oh, okay, can you hear me now?
Yes, we can.
Can hear you now.
Sorry about. Okay, so like I said, I'll be taking us on the lawful database processing, and we'll be starting with an introduction as to what data processing entails. And from our definition here, we have data processing within data protection, falls within the data protection and privacy, encompasses a range of operations on personal data. So basically, data processing is the conversion of raw data into meaningful information that can help in crucial decision-making for research purposes and that can be used to achieve a particular set goals or objective. So data is only as useful as how well it can be converted. And in order for data processing to take place, basically there are 5 stages in which a data can be processed. The first one we have is data collection, that is acquiring personal data, personal identifiable information or sensitive information. And then secondly, we have the recording, that is the storing of those personal data, either electronically, physically, or digitally. Now, the third process is the storage aspects, which is safeguarding those data to prevent unauthorized usage. And then fourthly, which is the retrieval, or basically the usage of those data. Now, the retrieval encompasses that's the usage of those data in accordance to authorized purposes or the specific purposes in which those data were collected in the first place. And then finally, we have the deletion, which is the removal of those data when it is no longer used. Now, it is essential that organizations ought to delete data they are not using so that in the case of breach or any violation, they won't be held subject to they won't bear the consequences of any data breach. And then the goal is that this helps protect privacy, inform individuals about data usage, secure data from unauthorized access, and respect individual rights. And then next is the legal framework of data protection in Nigeria. Now, basically, we are looking at the mechanisms for data protection, and then the legal framework in Nigeria is basically the Nigerian Data Protection Act 2023. And for the cross-border and the international data transfer, it's basically governed under Part 8 of the Data Protection Act, which encompasses Section 41, 42, and 43. Now, this part of the Nigerian Data Protection Act regulates the transmission of data from one country to another. And then next, we now have the lawful basis for data processing. Now, for data to be processed, there are certain principles that need, or certain guidelines that need to be upheld in order to process those data lawfully. Now, whenever these processes are not followed, then such data controller or processor will be subject to investigation, and if found guilty, will bear the consequences. Now, the very first and the most important of all is the aspect of consent. Consent. For any data to be processed, it is very vital that the organization obtain the consent of the data subjects. No matter how little that data is, it is very, very important that the consent is obtained, and not just that it must be obtained, such consent must be voluntarily given. If the data subject can prove that such data was not given voluntarily, then it violates the principles of data processing. And then secondly, it's contractual necessity, where the parties to a contract are privy to the data of a data subject, and that contract can only come into life only upon the assessing of those, only upon the assessing of the data of the subjects before such contracts can come into place. For example, is when we have a bank going into a loan with an individual, and then it is very necessary for them to obtain certain information about that individual. Until those informations are obtained, the contract cannot be fulfilled. So where there is a contractual necessity, then it forms a legal basis for obtaining such data. Thirdly, we have legal obligation. That's in fulfillment of a court order, or where the law specifies that such data should be provided, then it becomes a basis, a legal basis, or a lawful basis for obtaining those data of those subjects. The fourth on our list is vital interest. Now, where there seeks to protect the interest of the data subjects in the case of an medical emergency, then any data obtained as regards to that data subjects, such data will become a lawful basis for obtaining or for processing that data of that subject. Then the next is we have is legitimate interests, which basically involve the interest to protect it's similar to the fourth one, which we looked into vital interest, but this time around it involves legitimate interest. Processing can be lawful if it serves the legitimate interest of the data controller or a third party, as long as it doesn't infringe upon the individual rights. And then next is for public tax, where it involves carrying out a tax for the interest of the public, and then the data of that data subject is needed, then it is very vital and important to obtain that data, and then it becomes a lawful basis for obtaining the data. Please, are we all together? Are we following?
Yes, we are.
Yes,
Okay.
I'm following.
Then the next is special category data. Here it says additional conditions applies to sensitive data, such as healthcare or racial information, such as explicit consent or processing for health or social care purpose. And then we have children consent. Now, when processing involves children data, specific consents may be needed depending on their age and relevant data protection. Now, in obtaining children consents, the question now arises as to can a child under the statutory age give consent to his data? Now, that's a question we'll be posing. Can a child under the statutory age in Nigeria give consent in obtaining or in processing his data? And then from there, we move to the consequences of the breach. Now, when a data controller has processed data following the collection, the retention, the deletion, all the processes that are necessary, and what then happens where there is a breach of those data, where those data are not properly safeguarded, where they are not properly kept in confidential, or where there is an unauthorized use of those data, there are various consequences that will befall such data controller or processor. Now, in regards to Nigeria, particularly under section 46, 7, and 48, there are guidelines as to the consequences that will befall a data controller if they are found guilty of such breach. Now, some of the consequences include they could be fined, And based on Section 48, we have, they could be fined a sum of 10 million naira or 2 million naira, depending on the level of the breach, or the data controller could be made to forfeit 2% of their gross annual income as relation to the breach. And then also we could have jail term of not exceeding 1 year for the data controllers. Also, we have penalties for data controllers and processors. Administrative actions also could be taken upon them. And then penalties, there could be penalties for cross-border data transfers. So it is very essential that data controllers and organizations comply with the provisions of the Nigerian Data Protection Act in order to ensure that they don't fall foul of this data processing, and as such, these consequences will not befall them. And then now we look at international data transfer. So basically, international data transfer involves the transfer of personal data from one individual, from one country to another, where the recipients or the sender of those data are not the data subjects. So basically, it involves transfer of data that has been processed, has been collected from a country to another country. And in Nigeria, the international data transfer is regulated under Section 41 and 42 and 43 of the Nigerian Data Protection Act. Now, in order for a country to lawfully transfer data from its mother country to another country, there are certain guidelines that must have been fulfilled or that must be in place before those data can be transferred. Now, the first we have is adequacy decisions. We also have standard contractual clauses. We also have binding corporate rules, data localization requirements, surveillance concerns, and technological challenges. Now, we'll look into each of them gradually. Now, first and foremost, we have the adequacy decisions. Now, what this entails is that for a cross-border data transfer to take place, the country must have adequate level of protection in regards to that data. So where a country does not have a principle to protect those data, then such data transfer cannot take place within that country. And then we have Article 45, sub 1 of the GDPR, that's the General Data Protection Regulation. Secondly, we have standard contractual clauses. Now, these are pre-approved contracts that enable data transfer to third countries and must comply with GDPR requirements. So basically, parties can use them in data processing agreements to ensure lawful transfers. The next is the binding corporate rules. These internal policy guide data transfers within multinational organizations and require approval from data protection authorities to ensure international compliances. And then we have the code of conduct or certifications. Now, organizations can adhere to approved code of conduct or certification mechanisms specifying data protection safeguard. Now, for Nigeria, for example, in Nigeria now, in Section 43 of the article, that's of the Nigerian Data Protection Act, rather, it provides for certain steps that needs to be, or certain code of conduct that needs to be in place before an organization can facilitate data transfer to third countries. And then we have derogations. In specific circumstances, data transfers may be allowed without relying on the major mechanisms, such as consent, contractual performance, public interest. Now, derogations is basically like the exceptions to the general rule, the instances in which data may be transferred to other countries without having to comply with all those provisions that are stipulated in the Acts. Now, we now go to data transfer under Nigerian law. Now, the Nigerian Data Protection Act of 2023 outlines the rules for transferring personal data from Nigeria to foreign countries or organizations. Now, data can be transferred if the recipient abroad ensures an adequate level of data protection as confirmed by the National Information Technology Development Agency. Now, this is basically what the part 3 of the Data Protection Act is all about. And we've looked at adequacy level of data protection. So this is the fulcrum of transferring data from one country to another, that there must be an adequate level of data protection. Now, Section 41 of the Act specifies that data controllers or processors cannot transfer personal data out of Nigeria unless now these are the grounds in which they can transfer those data. Unless the recipient abroad is subject to a law, that's 1, 2, corporate rules, 3, contractual clauses, 4, code of conduct or certification that guarantees adequate data protection. So you can see that in everything, it all boils down to ensuring that there's adequate data protection in transferring those data. Now, if specific conditions in Section 43 apply. So if we go to Section 43, we'll see other conditions that it provides for, that where those conditions are fulfilled, then in those instances, data can be transferred. And some of those conditions include the consent, in which we've looked at obtaining consent from the data subject, then the data can be transferred from one country to another. Now, the data controller or processor must document the basis for the transfer and the adequacy of protection. Section 42 outlines the situations in which personal data can be transferred outside Nigeria. This includes obtaining the data subject's consent, transferring data necessary for contractual performance, data subject benefits, public interest, legal claims, or vital interests when the data subject cannot provide consent. So overall, in all and all, the Act establishes stringent criteria for international data transfers, emphasizing data protection and consent. And the whole essence of why the Act provides stringent criteria for international data transfer is so that when there is a breach, we can easily trace the root of those breach and then provide solutions to minimize the impacts the breach will cause. Because whenever there's a breach in data, it's the impact can be grave depending on the nature of the data that has been breached. And that's why we've looked at the sensitivity levels of data. So where we have a high sensitive level of data that has been breached, such as sensitive personal identifiable information, the impact it causes on a nation or on an organization, it's very, very gross. So in conclusion, understanding the lawful basis for data processing and international data transfer is essential to data subjects and also to data controllers and processors. Now, organizations must always identify the appropriate lawful basis for data processing, and also they must document those lawful basis for processing those data. International data transfers come with complex challenges due to varying data protection laws, privacies, regulations, and technological considerations. Organizations must employ compliance mechanisms to navigate these challenges. Now, that will be all for our presentations. If you have any questions, you can ask, and thank you very, very much.
A huge thank you to the both presenters. Somehow, magically, we've been able to condense 1,000 textbooks on data protection into an hour, barely. So yes, thank you for doing your research and making it insightful. And now we welcome our speakers. Okay. Yes, our first speaker is here, Mr. Solomon. We read his profile and we are prepared to write down his nuggets of wisdom. So yes, Mr. Solomon, we've been looking forward to having you.
Okay,
the floor is
can you hear me?
Yes, we can, sir.
Congrats, Dr. Ibeke. You know, for some times now, I've not been able to join, and I really don't know what's been wrong with my Mac. I tried to fix it, but then so just today, I think I was able to crack the add nut. So I hope you can hear me now.
Yes, we can, sir.
Okay, so great. So yes, I realized that the two groups are presented. I've not been able to go, through the presentation in details, but then of course, I think I followed the second group. Yes, just like you remarked, there were the coverage was quite expansive, and for me, if I have that presentation in my hand, I will say these persons have mastery of data protection, and of course, this class will not be necessary anymore. So let's just promote them to the status of senior consultant. But then there's something I'm going to say, which should be fundamental today. I think in all, let us prioritize practicable knowledge over and above head knowledge. I don't know whether that makes sense to anyone. Can you hear me?
Yes, sir. We can.
Okay, great. So what I mean by that is that if we look through what we have done, there are quite a number of folks that could, repeat the same thing our group has actually put together. But when it comes to applying those things to reality, to life cases, we actually may have a little challenge, and of course that's where the way be. So just while the presentation was going on, I realized that there was actually a recent decision, though not in Nigeria, where voice call recorded, was taken up as a violation of right to personal data. So, and if I was going to ask this question, maybe not quite a number of us will agree that such a conduct or an act, constitute violation of right to personal data, but it indeed does. And that's actually why, for us, I think as we begin to, no matter what the remark is, on our presentation, when we take our presentation, we go back to our private places. Let us begin to look at each of these points, our position, and how they can play out in real life situations. Trust me, that is what distinguishes a consultant, an expert, a professional than an enthusiast. I want to believe that the whole essence or the whole goal of this participation is not to remain enthusiastic, because I'm aware at the beginning, some of us introduce ourselves as enthusiasts. But then it's fine to start as an enthusiast. But please, you cannot afford to end, or continue for a long time in your career journey and still begin to introduce yourself as an enthusiast. And trust me, am I saying, oh, at the end of this class, you should begin to introduce yourself as an expert, as a consultant? Not necessarily. But then, by the time you have put together some literary works, by the time you have put together some case laws, by the time you have put together consulting, jobs, then you are now an expert, an industry expert. And that's what this program is meant to produce in us. So one of the things I realized is that I don't know whether group 2 did much of that. I realized that group 1 did much of that. I realized that group 2 did not. So who presented for group 2? Group 2.
Did, sir. Yes, sir.
Okay, your name, please. Oluwafemi, right?
Yes, sir.
Oluwafemi, what is wrong with NDPR? I didn't get to see NDPR frequently in your presentation.
Okay.
Or maybe I'm wrong, maybe I didn't follow.
No, sir, we didn't make much reference to it.
Why?
I think it must have been an oversight.
Okay. Who presented for group 1?
I'm here, sir.
Your name, please.
Churemi Gumbo, sorry.
Churemi. So if
Yes.
I want to be your hype man, it's going to be quite easy for me. Okay, so now so what happened? Did you guys refer to ND, or did you really cite NDPR in your presentation?
Yes, sir.
Just as much as you cited NDP?
Yes, yes. Because most of what we did was not really based off law, like when we talked about types of data sensitivity, that is data sensitivity levels, is not factored in the NDPR. But for the ones that were there, like data collection, data processing, we made reference to the NDPR.
Okay, so let's go back to Oluwafemi. Oluwafemi.
Yes, sir.
So is it that you thought or you believe that NDPR has been repealed, or it's no longer relevant? Or I mean, why did you leave it out that much?
Okay, I think basically it's the major reason was because NDPA is the existing law now, and then we're not really sure as, sir?
Say that again.
Okay, NDPA, it's the current act that regulates data protection. So I'm guessing that's how we focused our energy more on NDPA, and out of oversight, neglected NDPR.
Mr. Oluwafemi, you are an expert.
Yes, sir.
You cannot guess. The best thing an expert do is that expert just talk to. Imagine Cherebe is your client, and he's saying, he's putting you on a hot seat and say, please, can I have your opinion right now? Now, and as an expert, actually you are not sure. Most likely you will not say, I guess. The fate of his business, of his business balance sheet cannot be premised on your guests. Do you agree with me?
Yes, sir.
So as an expert, the very best you can do is to say, oh, Mr. Cherebe, can you just give me some time now? I'm going to go back to you. Is 7 p.m. okay? Now, you are not necessarily telling him that you are not sure, right? You are not necessarily telling him that you are guessing. But because at that moment, presumption of knowledge, of expertise is reposed in you, it's in your favor. So, and am I alluding to the fact that an expert must know all things? I'm sure you know I'm not alluding to that fact.
Yeah, well.
But because there's that presumption of knowledge and expertise in your favor, so now, it's not everything that is taught in within the 4 walls of the school. So, and some people will call something street knowledge. They will say you need to be streetwise. At that moment, you don't need to tell him that, Mr. Churin, I don't know that. I cannot lie. You see, I'm a very straightforward person. Please, I hope you don't say that. I mean, even beyond data protection, I hope nobody as a professional here will say that someday. Say, I cannot lie. It is what I know, I will know. I know. It is what I don't know, I will not say I know. I hope nobody will say that here.
Very well, sir.
Mr. Oluwafemi.
Yes, sir.
I said, I hope someday, no day will come that you will say, I cannot lie. If I don't know it, I don't know it. So maybe give me some time. When I know it, I'll come back. I hope you never say that.
No, sir, I won't, sir.
Please don't fall my hand and don't fall the hands of everyone in this. So when you don't know, when you don't even know, you are not sure. Now, all you need to do is, Mr. Chairman, that's okay, that's fine. So this is what you want to do. Trust me, you can give me 24 hours. I mean, I've got a whole lot of things in my hand. So let me get you something, something you can rely on, so something you can actually take even to your team members and discuss, and you get back to me. Is that okay? And you say, that's fine. Meanwhile, it doesn't know you don't know it at that point. So right. So it just fits, why? Sweet wisdom. So now my point is that as of today, as much as NDPA applies to protection of regulation of governance of personal data in Nigeria and of Nigerians outside Nigeria, that's what that NDPA says. So we still have mean, many of us still have dissertation about that. How you want NDPA to apply in the United States, you know, to the governance of personal data of Nigerians. You know, that's what the NDPA is. But we are saying we have a reservation, and we think that's actually could be quite challenging. You know, NDPA tries to be very ambitious, just like GDP. Now, but we are saying as much as it applies to personal data of Nigeria, and the NDPR also still applies to personal data of Nigerians. And if anybody is not checking that, you need to look at your NDPA very well. So NDPA says, and if anybody knows the particular section, within the next 1 minute, I have a gift for that person. There's a particular section that preserves NDPR. And not only NDPR, all implementation frameworks and regulations under NDPR. Does anybody know it? Go in. Mr. Luafemi, I saw what you did there. Mr. Chiremi, do you want to help this assembly? Hey, Favor is raising up his hand. His hand. Favor, can I have you? You can unmute yourself. Let me have you. Can we have Favor? Favor, can you unmute yourself? What? So nobody.
Hello, sorry.
Okay.
Can you hear me?
We can hear you, but it's
Okay.
past 4 minutes already.
I said the new act that
Yes.
the NDPA in section 64(2)(f), it retains the lists, some of the lists introduced in the NDPR, and then section, that should be section, is it 2, that made a statement on including laws, existing laws, as long as they are not inconsistent with the NDPA. That should be section 2, right? Something like that.
What? So you told us something like that, but no matter what it is, it's over 1 minute already. But that's okay. That's okay. For the purpose of group 2, I think what you've done is you have left it out. Let me give an example. Do you know that within the last 2 months, I have filed about 8, data protection cases, and I can tell you categorically, 7 of them were filed on NDPR. Because as a matter of fact, the interesting thing is that one of them, which is a very important case on data protection, it was as at the time the violation, alleged that case, occurred, NDPA was not in existence. Right. So, but the good thing is that even after NDPA has been passed, NDPA now saved, we call those provisions saving provisions. So NDPA now saved NDPA. That's the problem. Number 2, are you aware that, so let me say, there's a provision of section 28 of the NDP. That provision talks about data protection impact assessment. Now, all that provision does is to tell you that, look, when a process is likely to result in high risk to rights of natural persons, then data protection impact assessment has to be conducted. Now, but that provision does not give us instances, of examples of nature of processing that can result in high risk. But if you check the provisions of implementation framework of NDPR, it gives us about 7 of those instances where data protection impact assessment is required. Just a couple of weeks ago, some of us met, myself, my different partner, and a good number of other lawyers around the country. We had a roundtable where we discussed the very cogent issues in the NDPA. And one of the things we did was to make recommendation for NDPC, which is regulated. And of course, like I said, now NDPA section 28 does not even contain the instances of process that will amount to likelihood of high risk to personal data. Whereas implementation frameworks of NDPR actually contains about 7 instances. So in that case, you cannot afford to leave NDPR out unless and until NDPA clearly abrogates NDPR. Is that clear enough? Hello?
Yes, sir, it's clear, sir.
Now, there's something also I need to, a number of times, I've actually commented on this, but I'm aware it's not this set that I've committed, that's where I've made the comments, But then I think I also need to bring it to the attention of this set. Now, group 2, in your presentation, how many case laws did you cite? Hello? Hello? Can you hear me?
Yes, sir, we can hear you, sir.
I asked a question. How many case law did group 2 cite in their presentation? I'm asking. Oluwafemi. Oluwafemi.
Okay, sorry, sir, my network was giving me issues. We didn't cite any, sir.
Ah! You did not cite any.
Yes, sir.
Okay, let me assume your group is a group of journalists. Is that correct?
Yes, sir.
I mean, your group is a group of journalists. You are all just journalists.
No, sir.
Bloggers.
No, sir.
Accountants.
No, sir.
What are you guys?
Huh?
What are you guys?
Yeah, lawyer, sir.
Jesus Christ. Don't let me talk yet. Churemi.
Yes, sir. Yes, sir.
You presented for group 1.
Yes, sir.
How many case law did you cite?
We didn't cite any case law, but we made mention of the recent notice of investigation from the Commission to OPDHL and Meta. So I think that should pass for us.
What did you say? What did you say that again? The last statement you made?
The recent notice of investigation.
You said
OP.
you think that should pass for you. You think. Who are you?
Sorry, sir.
No, don't say sorry. Who are you to think? Now you to put your work together, you presented it to an examiner, and you are telling the examiner, I think this should be sufficient. Oluwafemi. Justice Oluwafemi.
Yes, I can hear you, sir.
Please take over the bench on the matter filed by the legal team, eminently led by Churemi. Are you convinced? In fact, how did that statement come across to you? That he thought that should be sufficient. Do you think he's in a position to think that what is sufficient or not for your court?
Yes, sir.
Can I have some remarks for him from you? When he's thinking for the court, he's thinking for your court. What would you rather say to him?
Sir?
What would you rather say to him when he's thinking for your court? He's thinking that should be sufficient. My Lord, that should be sufficient for you. What will your court say to you? It doesn't have to be a legal decision. Let just hear a statement from your court to him on that.
I'm short of words.
Yeah, short. Yeah, short of words. Okay.
Yes, sir.
Chiremi.
Yes, sir.
This gentleman has led a team of other legally involved before your court. Yes. And you're asking the counsel, I read this court on the paucity of case laws in your brief. This court needs to be guided. And the counsel, the lead counsel, just told you that, my Lord, I'm short of words.
Wow.
What are your words for you?
It is impossible for a counsel to be short of words. So he should come up with.
I need you to say something to you. No, don't worry. We'll adopt the Chatham House rules. Whatever is discussed within the Chatham House ends in Chatham House. If you want to talk that shame, please, my Lord, proceed.
No, sir. No, sir. Not before your honorable presence.
Okay, guys. Sincerely speaking, I will need you guys to do better. You know, when I started, I think maybe your group of two, on a very light note, I said, are you guys a team of journalists? And you told me, are you guys a team of bloggers? You said, are you a team of accountants? You see, one of the things that even at the level of law students, you could see some other students from other courses being envious of law students, say, in Adekule versus this, in this, and even some of them, they sound as if all the laws in Nigeria are in the constitution. Now, so as much as they are not lawyers or law students, they understand that there's actually the importance of case law in our works. And you and I know very well that case laws are what give life to interpretation of legislation and regulation. They are what makes understanding of laws and regulations easier and more relatable for us and for the rest of the society. And as much as data protection is still an emerging, this room cannot tell me, I'm talking about gentlemen in this room, you cannot tell me that you don't have case laws on almost all of the subjects you have discussed this year. If you cannot remember any, and I'm not just talking about foreign, I can give you at least 10 case laws from my head. I mean, often here as I'm talking to. Of course, a good number of them I'm involved in. You know, I'm involved in them one way or the other. So, and much more, there are enough case laws in Europe, in America, even in the rest of Africa, particularly Kenya. So please and please, cultivate the habit of, enriching your research with case law. When you give us case laws, it makes us understand the subject better. When your case law is not properly applied, some of us who have come across it can say, hey, counsel, your case law, the case law you actually cited does not discuss that person. No, your what you applied in this your presentation, it's only an obiter. In fact, no, it's a position of the dissenting judge. No, we disagree. That was not what the court said. So it makes the conversation engaging and interesting. It makes all of us to learn better and faster. And let me send this as a note of warning. The next time we have a presentation, if I cannot see case law in your presentation, I will ignore it. Did that make myself clear?
Yes, sir.
Yes, sir.
I am not difficult to do, but trust me, and even within the last 15 minutes we'll be talking of thereabout, you realize that I could be quite, interesting and warm, individual to relate with, even when it comes to work. But because I don't want us to just come in, have chats, here and there, laugh and go away. I want us to become not only repository of knowledge, but people that can be called upon, and that whether you're a year at the bar or 2 years at the bar, you will be called upon with an opinion on data protection, and your opinion will actually, solve problems that some so-called established experts will be rattled by. And that is the essence of it. Like I keep saying, application of knowledge is the justification for its acquisition. Did somebody get that?
Yes, sir, we did.
Yes,
So I
sir.
say that again. Application of knowledge is the justification for its acquisition. For the records, I'm not a motivational speaker, and I don't intend to aspire to perspire and Maguire. So, but if you unpack what I've just said, it simply means when you apply knowledge, it now justifies the reason, the whole essence that you have acquired it in the first instance. If you fail to apply knowledge, then the whole essence of you acquiring it is not justified. Does that make sense to anyone? Hello?
Yes, sir. It does.
I mean, that makes your sense clearer and better than application of knowledge is the justification for its acquisition. But that sounds like rant that motivational speakers and pastors do. I'm neither one. I respect, I appreciate it. I'm neither one. So please, I beg you, I appeal to you, for the purpose of, how many other classes do we have?
Sir, there are, for data privacy and protection, there are 2 more classes, sir.
Yes, those 2 classes, please, your presentation, you must list out all the cases. In fact, you know what I'm going to do? When your presentations are sent, forwarded, because they always forwarded ahead of time, I will look through them. The moment I can't see case, I will just send an email that please, this group should not be allowed to make a presentation. Do you agree I should do that? Do you all agree I should do that? Do you all agree I should do that?
Yes, sir. Yes, sir.
Don't worry. Don't worry. Don't even agree. I am the mentor here. Is that correct?
Yes, sir, you are.
Aha. So whether you like it or not, but guys, honestly, you are going to find. And for some of you who don't find, now I can even share with you a compilation of digital right cases by Digital Lawyers Edition, which we compiled, which I was part of. So one way or the other, some of you will find some cases, and there are lots of other cases I can also share with you. So, but then I think if you want to be serious, we should not even wait till Solomon shares cases, case of. You know why? Because we are experts like Solomon too. Some of you someday, I look forward to one day being a courtroom and you are the counsel of the other side. I will just say, okay, okay. That's how it should be. Please. So, but then If you want me to oblige you the compilation of cases, I'm going to oblige you. Don't worry. But I can assure you, if your presentations are forwarded to me ahead of next Saturday, and I can't see case law, I am going to be emphatic. You will not be allowed to present. Is that noted?
Yes, sir.
Okay, so on this note, I think I would love to stop here. Though there's something important I think some of us miss. I mean, the two groups miss. Maybe I don't know. Maybe we can leave that to next class. And that is the fact that we should know that first of all, data protection is an offspring of privacy. I'm sure we know that. Do we know that?
Yes, sir.
Yes, sir.
And both the mother and the child, they are not absolute. They are right, and they are not absolute. Do we agree that they are not absolute?
Sorry, sir, we can't hear you.
Do we agree
Sorry,
that
yes.
data protection and privacy are not absolute? They are not absolute, right? If you disagree,
Why is that, sir?
we are experts. If you disagree, I mean, it may just be for the fun of learning. Then, guys, please let me send a note of one. You see, look, maybe the next 30 years, I can now say, yes, guys, I know more than you. There's nothing I don't know. Which is the lie. Which is the lie. Pastor, today, there is something like, right? And I appreciate the fact that we all should learn together. If you are not clear, sometimes you are not clear, just tell me if you disagree. And let us discuss. Do you all agree that data protection rights and privacy are not absolute? If I do you disagree or do you agree?
Yes, sir.
Which one is yes, sir?
It's
Yes,
not
sir.
absolute.
It's not absolute, right?
Yes, sir.
Yes, sir.
Okay. Does anyone here know the provisions for exemptions or limitations of right to data protection, even under the Okay, if you don't know, maybe after the class, just check your NDPA and check section 3, check subsection 2 from A to F5. You will see instances where those rights, to your personal data are exempted.
Section 43 too.
Section 43. Okay, so what's in section 43?
That's on derogation.
On derogation. Okay. So for section 3, so elaborate. So let me even quickly, and please, who is the moderator for today? It's our time up. It's my time up. I think it's the time I should be asking. I want to
I'm the
check.
moderator.
So it's my time up.
It is, but I guess you can go ahead.
Okay, thank you. God bless you, madam. Okay, so is it Favor that spoke now? Favor is my.
Yes, sir.
Which one is your name? Favor. Favor.
Sir?
Is it, you said section 43?
I said, I believe section 43 should be among two.
We have to read out the particular provision.
It has to do with derogation in relation to cross international data transfers. It came as an exception.
Well, yeah, I got it. But when you look at it, it's actually not because I'm sure you're looking particularly at
Public interest.
yeah, public interest, yes,
Legal claim.
that's for 3. But when you
Yeah.
look at you realize that this is actually an offshoot of section 3, subsection 2. So I'm in section 3 right now. So, and if you look at subsection 2, it says subject to the right and freedom under the Constitution and the limitation. The obligation under part 4, other than section 24, 25, 32, and 40 shall not apply to a data controller or processor if the processor of personal data is 1, carried out by a competent authority for the purpose of prevention, investigation, detection, blah, 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 blah. Carried out by a competent authority for the purpose of prevention or control of a national public health emergency. Carried out by a competent authority as is necessary for national security. In respect of publication in the public interest for journalism, education, artistic, and literary purposes. Necessary for the establishment, exercise, or defense of legal claim, whether in court proceedings or in administrative or out of court proceedings. So when you look at it, favor, this section 3, subsection 2A to E are essentially the exception to your right to personal data under the yeah. If I have my way, I would actually want this class to do, maybe everyone to just do like a 1-page or 2-page task on exemption to personal data protection. But I think I'm not in, it's not in my power to give such a task. I will not arrogate it to myself unless I'm to discuss with the management of JIIPCC and consent given. But then, in the absence of that, please, I want you to familiarize yourself with this exemption. Now, it is not just enough for us as professionals to claim, yes, this is position, this is the law. The same law says, in these instances, your personal data, the protection can be expensive. So imagine we are somewhere and somebody say, no, it's not absolute. In this case, and you're looking at the person. So you should even be the one to say, subject to the provision of section 3, subsection 2A to C or to E of NDP. These are your. So, gentlemen, the law says we should not call you some of you. At this point, I think I want to stop here. If you have the question I need to respond to, I'll be glad to do. But please, very importantly, take note of the application of case for subsequent cases. Thank you.
Thank you so much, Sarah, for making this a very insightful and impactful session. I once interned at Harlem Solicitors, and it was you giving out this knowledge again and making it just as impactful. So thank you again for leaving this indelible mark in our memories.
Oh, seriously? Oh, you want?
Yes, sir.
Oh, that's okay. That's okay. I'm so glad.
So, yes, for letting us tap into your well of wisdom. And
I'm so sorry.
Again,
I'm so sorry. I think I can see Michael Ade. I think Michael Ade. He already uploaded the. Yes, it's already supplied the link to that compendium. That's thank you so much. Then Genga, is Genga still in the room?
Yes, sir. Yes, sir. I'm here, sir.
Genga, were you in Lasso or are you still in Lasso?
Yes, I'm still in Lasso, sir.
Okay, now you are doing an.
Yes, sir.
Yes, sir. Okay, so I just want to thank you so much for doing that.
It's fine, sir. Thank you very much, sir.
Okay, at this point, we are going to leave the floor open for questions. Do any of our mentees have a question for our speaker? And I would advise you to have a lot because this is a good opportunity to pick his brain on the topic we've discussed or anything across data protection and privacy. So yes, bring forth your questions. Okay, we already have one in the chat box. That too. The first one is, considering the state of law enforcement in Nigeria, how effective has it been to implement the sanctions against defaulting persons? Mr. Solomon. Sir, are you still with us?
Yes, I'm here. Can you hear me?
Yes, I can hear you. I would read the first question again.
I got it.
Okay.
Maybe on a very light note, I would just say that question should be directed to NDPC. But then, when you look at it, I also need to be careful that when we are talking about enforcement, there is administrative enforcement and there is judicial enforcement. The administrative enforcement, essentially, it's NDPC that should be able to answer the question on that. But then, when it was NDPB, before the advent of NDP, we actually witnessed some of the enforcement it actually undertook in that capacity. But then at the same time, can we really say its enforcement has been effective? Modesty and honesty, my answer would be no. Because in the first instance, what is the sensitization on the issue of data protection in Nigeria? What is the level? To what extent has the knowledge penetrated the ecosystem? Now, let me give you a figure you can relate to. In 2016, May 25, 2016, GDPR was issued. And guess what? That regulation, that framework was not going to be a law, was not going to be enforceable until May 25, 2018. That was going to be 2 years after the issuance. So the 2 years, that preceded the enforcement was dedicated to massive sensitization of all stakeholders, the right holders and the duty bearers across all the entire European Union. So, but do you want to compare that with NDPR that came to force the day it was issued, or NDPA that came to force the day it was issued? Let me give you an example. So one of the lawsuits are filed now, and before I filed it, I did an FOI request. FOI request is freedom of information request to the data controller. It's a public data controller. And so what I did is, and in my request, I alleged there was a violation. Oh, sorry, there was an alleged violation or a threatened violation, because there was actually a news. There were reportage. Many reportages of that alleged violation of their data. And that's, I want to know if they complied with a particular requirement of NDPR, which they should have complied. So in reply to me, they said, well, we know that what this thing you have identified is a requirement of NDPR. But we also, while we are studying that, we also need to let you know that we have uploaded NDPR on our website. I found that so ridiculous. Now, the NDPR requires them to do undertake a particular task. And they agreed with me in one breath that is a requirement. In another breath, they went ahead to say they have uploaded the NDPR on their website. Who cares? No, honestly, who cares? You see, the purpose of uploading NDPR on the website is maybe at best for access of your audience. It does not even mean that you are going to you want to choose to be banned by NDPR. So for me, when you look at that, the whole essence of getting when that happened, the next thing I did was to approach the court. I went to the court. No, these guys are jokers. You can't be telling me because you have uploaded the NDPR on your website, you have complied with what NDPR provides. So if you are asking me what it has been, so far so good, I would say by the regulator, when it comes to administrative enforcement, it has not been quite impressive. And when it comes to judicial enforcement, in that situation, my blame will not be at the doorstep of judiciary. And I'll tell you why. Unlike the regulator, who has a mandate to go after compliance by its enabling law, the judiciary is meant to sit down where it is. Then Oluwafemi, Oluwagbenga, and every other person approaches the court and says, my lord, my right to personal data has been violated, and I want this redressed. So for me, I'm not sure I can actually pass a vote of no confidence on judicial enforcement. But I think if I have to blame, I would rather blame the stakeholders, all of us together. We still have which NPC is part of. We need to fully sensitize the public so that they know that they have their rights. Then, of course, the other stakeholders in the ecosystem, including the MBA, then we need to look at it, how we can make legal services on data protection easily accessible, affordable, or on pro bono basis to indigent citizens of our society. So, does that answer the question?
Yes, it does, sir.
Great.
That would lead us to, okay.
Let me take question two. I'm not sure how much other question I can take. Let me take question two. Question two says, what court has jurisdiction on this matter? Who has those questions? Let me know. Dennis.
Sir, the questions are from the group, well, I think group 2. These were the questions they asked after they made their research and compiled their presentations.
Mr. Dennis and group 2, all of us. I am still asking the question too myself. But seriously, so I've gone to court to ask that question. So there's a case now, Solomon Kidera and AGA. So I've gone to court to ask that. And I'll tell you why. Is it that I don't have an idea or I don't know? I know. But I'm saying, if we're going to be serious professionals, if we, well, you see, look, a law must be able to do, let me ask you this question. Do you all agree with me that a law must be able to give citizens notice in advance of their rights, their duties and obligations, and let me say, mechanism, the right mechanism for seeking redress in case those rights are violated? Do we agree with it? Do we agree with it? Chief Dennis. Chief Dennis.
Sorry, I didn't get you, sir.
Do you agree with me that the law is meant to give citizens very clear information about their rights, duties and obligations, and mechanism for protecting or redressing them?
Yes, sir. I believe it's your right, sir.
My mind is telling me you don't. My mind is telling me that you think it should run like Ifa oracle or an oracle consultant, where it is only the Babalawo that will just cast the beads and will say, my son, my daughter, Anthony, my daughter, my daughter, Agona. The way I'm looking at it. Do you think that's the way the law should work?
No, sir.
No, the law should be clear enough. Now, let's go to that law, NDP, section 16. Now, it says section 5051 says if you are aggrieved and you believe your rights are violated, you can approach the court. 51 says if what is it called? You are not satisfied by the decision of NDPC, you can seek review by the court. Now, the two of them, those two sections use court. And section 65 says, court under this law shall mean any court of competent jurisdiction. Dennis, what does that mean?
Sorry, sir, can you come again?
Section 50 and 51 of the NDPA both refer to court. One says, if you are aggrieved, if you believe Oluwafemi has violated your rights, he runs the company and he's been chasing you that come take loans. We have loans at affordable rate. We know you're a gentleman, and you believe you want to support his business. Then you took loan yesterday. Now, from today, he has been disturbing you with calls. He has been sending messages to your contact that Dennis is on the run. He's an HIV positive patient. He's a fraudster. He's this, is that. Now you want to approach the court. Now you now take a copy of your NDP. You read section 50, says you can approach the court. Now go to section 65, getting to know which court. And section 65 says any court of competent jurisdiction. Please, which courts are we going now? Which court will you go to?
Well, I would say a court of appeal, sir.
Court of appeal?
Yes, sir.
When you said that, I had to sip a drink. So let me go to our moderator. What court will you advise? So you are now Mr. Dennis Hansen. So what court will you approach on his behalf?
On a light note, I think we'll go back to the Ifa Oracle.
Okay. Yeah, what court?
But then I think it should be the Federal High Court. Or at least that's the one people actually head of this matter. That's the one is mostly insisted.
But looking at that provision of section 65, what court does it?
But then the state high court has unlimited jurisdiction. So the argument is going to be between a federal high court and a state high court.
What about a magistrate court?
Oh no, it does not have jurisdiction. I don't.
It does not have jurisdiction.
Okay, it depends. Okay, I don't think so, though.
What is the meaning of a court of competent jurisdiction?
Okay, I believe the magistrate courts will have jurisdiction, but however, due to the nature of...
Go ahead.
Yeah, the magistrate courts will have jurisdiction, but when I'm looking at the remedies that will be awarded, that's the damages that will be awarded, it will be limited in its application, that's in its monetary jurisdiction. So the best place to go to will be the high court.
Senior counsel Femi, what about customary courts?
Well, the act says competent court, so customary court too will fall under a competent court of jurisdiction.
What about area court?
They're all competent courts.
I like that. So when any dispute arise, I want to redress my grievance, I can approach customary court.
I don't think the customary court is a...
Who are you to think? What? So you think? Oluwafemi.
Okay, sir.
Oluwafemi.
Yes, sir.
It's Michael in the room.
Yes, sir.
Ah, you need to contribute to.
Sir, I've been contributing, sir. My phone went off. I just came back.
Thank God your phone is back. So please, what do
Yes,
you
sir.
think?
So I wanted to respond in respect of customary courts and area courts that you mentioned. I think they don't have jurisdiction. And the reason is that customary courts and area courts have, the law gives them a particular jurisdiction to entertain certain matters.
Okay.
That is matters, customary court matters that has to do with that are related to customary matters in respect of sometimes land and other customarily issues like that. So I think in respect of breach of data privacy and protection, I don't think they have. I think they don't have any jurisdiction, sir.
Okay. So, but what do we do when Section 5 says any court of competent jurisdiction, any court of that's what it says.
Yes,
so,
the act may. First, I want to say that if you look at the Nigerian Data Protection Act 2023,
yes,
it says that first, it says that if there is a breach in respect of data protection and privacy, yes, the data subject can first of all petition to the Data Protection Commission.
No. It doesn't make it up. It doesn't make it a requirement. So let's go there.
But what I'm saying is that that's the first requirement provided by law.
No. It's not a requirement.
The person whose right has been breached.
Michael, just add on first. Let's go there. Now, okay. Section 50 says a person who is not satisfied. That is, if you have gone to the commission, who's not satisfied with another of the commission, may apply for the court for judicial review within 30 days after the order was made.
Yes.
Now,
I'm not disputing that.
No, wait. Section 51 now says a data subject who suffers injury, loss, or harm as a result of violation of this act by a data controller, data processor, may recover damages from such data controller or data processor in civil proceeding. Now, this is it. You call it civil remedies. As a matter of fact, let me say this clearly. Let's say this to you. I would think this section 51 is actually a bad section, the bad provision, the bad law. You know why?
Why? Why is that?
It focuses only on recovery of damages. It does not stipulate, because let me be clear about this. Now, it can never be, and please, I use the word never emphatically and consciously, that any legislation will foreclose the right of a personal data, a data subject, or subject the rights of our civil litigation to a precondition of petition to the NDPC. It can never be. In fact, such an issue arose in I think about 2 cases under the NDPR, and the court ruled, no, you cannot you cannot handcuff the hands of a data subject to the NDPC. The NDPC is not the court of law. It doesn't have the knowledge of a judge. It doesn't even have the power of a judge. So the position, some of these things, and let me let you know, one of the reasons why we have both administrative and judicial remedy is the fact that for administrative remedy, you may not have to spend a dime to lodge a complaint to the commission. But for judicial remedy, you know you're going to brief a letter. You know it will involve their reply, it will involve case law, and of course, all of that. And of course, sometimes the position gets adversarial and the court gives a position that is binding. And sometimes when the court grants a relief to in a litigation, it may have a far-reaching impact. For example, if you challenge a position and the court says this cannot be, now that position can not also only be implemented against other data controllers. In fact, it can be implemented against NDPC, and NDPC may also enforce it. So it's not subject to, you don't have to approach the commission as a precondition to litigation. And should you require a case law on it, which was even decided on NDPR, I'm going to freely and happily oblige you. Does that make any sense? Hello? Hello?
Yes, sir. We are still with you, and it makes sense.
As Michael left the room, Michael.
I guess he has network issues.
So now, like I said, I love the part that we are quite excited about, and I still want us to look at, and just like I will say, oh, I don't understand. How? Which court? Which court is when the court says, when the provision says any court of competent jurisdiction? Let me clarify something. Now, can anybody answer the question? What court would be a court of competent jurisdiction? In any situation. Okay, I have an answer for you because our courts have answered that question. Our courts have said, number one, that court must be duly constituted. Meaning, if that court is a one-man judge court, that one judge must be present. If that court is a three-man judge, the three judges must be present. If two of them are present, then that court cannot be a court of competent jurisdiction. Number two, it says there must be nothing, precluding or holding or preventing that court from exercising jurisdiction. For example, if the party does not have locus, then that's enough to prevent the party from exercising a jurisdiction. It says number three, which is actually the fulcrum of our position. It says that court, the subject matter jurisdiction of that court. Sorry, it said that court must have subject matter jurisdiction. So what is the subject matter jurisdiction? Does anybody know what a subject matter jurisdiction is?
Yes, in this instance, the subject matter jurisdiction will be on data privacy.
Absolutely.
That will be section 37.
Fantastic. Fantastic. Just want yourself a beautiful dinner. So just go out this night, dress up well, just enter a lovely dinner, a lovely restaurant, order for a meal, water, drink, maybe a bottle of champagne and pay for it and go.
Yes, sir. Bills on you, sir.
No, I didn't say, I didn't say just money from me. So, like Oluwafemi said, that's very hard. Subject matter jurisdiction is the jurisdiction on the subject matter. Whether it is data protection, cyber crime, freedom of information, drugs and narcotics, or whatever it is. Because the position of the law and of our court is that subject matter jurisdiction is donated by the Constitution or the enabling law or the statute. In fact, the position of our court is that parties and court cannot impart jurisdiction. Now, so when you look at it, almost all of you are partially right. Michael was right when he said, those courts, customary courts, area courts, they have their jurisdiction and all of that. So the court is saying, our court has said, you cannot infer. A court cannot say, I like this matter, data protection. I think I want to hear it. My Lord, you cannot hear it on the basis of liking data protection because you have been hearing it. Because my law's daughter have been talking about data protection. So my law also wants to hear it. No, sir. Unless the enabling law of that subject matter expressly confers jurisdiction on your court, sir. Whether it's federal high court of state, high court of FCT, or just high court. Do you understand? There are some laws that confer exclusive jurisdiction of federal high court. Cybercrime Act it confers exclusive jurisdiction of Federal High Court. While Freedom of Information Act confers jurisdiction on Federal High Court and High Court. Now, so in that instance, when you look at it, so we now need to ask ourselves, then there must be, Mr. Michael is back.
Yes, I'm back.
Yes, we know.
My phone went off.
Oh, I'm sorry about that.
No problem, sir.
We need to consider whether there was a violation of your personal data, then we may need to file a process tomorrow, Monday morning. So
I don't think there is any violation here, sir.
Oh, okay. So we may have to. That's why I said we may need to consider. So when we consider, we may need to bring in some cybersecurity experts to review. So, but while you were away, we said that our court have answered the question of what court of competent jurisdiction means. It means there must be, the court must be duly constituted. If it's a one-man court, that one-man judge must be in court. If it's a three-man bench, the three judges must be present. Now, if two judges are present, then that court cannot be court of competent jurisdiction. Number two, that court, there must be nothing that prevents that court from acting on that matter. For example, issue of local standard. If the applicant doesn't have local standard, then that court is prevented to exercise jurisdiction as a court of competence. Then number three, and more important, is that that court must have subject matter jurisdiction on that matter. And so the subject matter in this conversation, what is it? What is the subject matter in this conversation? Michael, what's the subject matter?
The breach of privacy to data.
Yes, data protection. Just call it data protection.
Yes, sir. Yes, sir. Data protection, sir.
So in that case, if that is the case, that means before a court can be seen as court of competent jurisdiction, that court must expressly become. Sorry, and let me also add it. Then our courts have now decided that how. And let me ask you, maybe if you know, how is subject matter jurisdiction conferred? Let me ask you, Michael.
Sir, it is either conferred expressly by law, that is the law, establishing that courts may give the courts, express powers to entertain such matter.
What? So what have we said is that our courts have not told us that you are quite. Our court have said subject matter decisions are either expressly donated by the Constitution or by the statute, providing for that subject matter. So let me give you an example. The Constitution provides for fundamental rights, right?
Yes, sir.
And it provides for the courts where you can seek redress in matter of contravention of fundamental rights. Is that correct?
Yes, sir.
The Constitution provides for matters on royalties, banking, intellectual property, and it also provides for the court you can approach. Is that correct?
Yes, sir. Correct, sir.
So our court also have said that other than the Constitution, subject matter legislation or subject matter statutes also can be the source of subject matter jurisdiction. For example, Cybercrime Act, Freedom of Information Act. Cybercrime Act, for example, provides that in this act, court shall mean federal high court. That means it does not include high court of every city. Is that correct?
Yes, sir.
That means it doesn't include high court of Lagos. Is that correct?
Sir, the High Court of Federal Capital Territory is not within the Federal High Court, sir.
That's what I'm saying. I'm asking you. I want you to confirm or.
Yes, sir. Yes, sir. Yes, sir. Yes, sir.
So federal high court is federal high court, right?
Yes, sir.
Freedom of Information Act says court under this act shall mean federal high court or high court. So when you look at those two, for example, NDLA Act provides for the court that also have jurisdiction. So now, so what I'm saying is that specific subject matter legislation always provides for the cost that has limitation. Right. So, and in that case, it says the data, that means, so what do you now expect? So now with this analysis, what do you expect of data protection?
So would I be right to say that the law, going by the provisions of the law has not given either the federal high court or the high court of the state to entertain matters that has to do with data protection?
Michael, are you asking me or you are making a position?
I'm just because from your explanation, if I can get you.
Mr. Michael, don't let us play politics. Don't let us play politics.
No, sir. Sir, it's not politics. This issue,
Mr. Michael, please take a position. Take a position.
Okay, sir, let me make a position, sir.
Yes.
Sir, I've read one time in the news where a particular lawyer dragged the Data Protection Commission to court.
Okay.
On this particular matter of jurisdiction. The person went to court for the court to determine what's appropriate court to, where matters that has to do with data protection can be instituted.
Yes.
And I think that matter currently, I've not read much about the matter, but I just read it in the flash, in the news. I've not gone through what's going on, but I think that matter is still pending before the Federal High Court here in Abuja. So the point is that I think going by the provisions of the Act, the relevant legislation in respect of data protection in Nigeria, I think the court has not given, the court or any court express, jurisdiction to entertain matters that has to do with data protection.
Lana can say. Lana can say, I'm afraid. Though while I'm afraid, I think is this case we're talking about. You can check. I'll put it in the chat room. Can we check that case? Can we check our chat room, please?
Yes, sir.
Yes, sir.
There's a link I sent it.
Yes, I've seen it, sir.
Maybe it's that case of that lawyer, right? Have we read it?
Yes, sir.
Yes, sir.
I've opened it. Yes, sir. So I think this is the case, sir.
Oh, this is the case. That lawyer went to court. We are still waiting for you. Somebody raised some his hand, Francis.
So it's like you're the one that went to court.
Really?
Yes, sir. Your name is there, sir.
Are you just me? Francis, let's have you.
Yes, sir. I think my position on that would be that the law presently lacks specificity on the court to approach. So it leaves, the provision leaves a broad interpretation of what should constitute a competent court of jurisdiction. So that lack of specificity is what's lacking.
So that broad room is this. That broad spectrum is this. What do you think will happen? So if tomorrow I go to area court, will you blame me? If tomorrow I go to Sharia court, Francis, will you blame me?
I won't blame you, sir. Yeah. But I would say that it will be necessary to be more compelling to err on the side of caution, because you might approach the Sharia court and the Sharia court might strike out your case for want of jurisdiction.
I know, but you see, no, don't just look at me as an individual. And when I mean me now, I'm not even necessarily mean referring to myself. Don't just look at me. Look at all of our stakeholders. Please, can we mute our microphone? We're not speaking. Francis.
Yes, sir. Yes, sir. I'm here, sir.
As a stakeholder, do you think it is ideal for you to have a law that citizens are not properly guided? Forget it. Look, let me tell you. I can tell you that both myself and almost everyone in this, if you want to file it, you may actually not file in the wrong court. But my point is that no, we cannot we cannot use yourself or myself as the test of the ideal man in the society. You are not an ideal man. You are enlightened. You are a professional. In fact, among lawyers, there are lawyers. You know it. There are lawyers that cannot construct a single sentence in English correctly. I've come across many of them. And when it comes to knowledge, we know it. We know, when I mean we know it, we know the expenses we have had with our colleagues. But I'm saying, no matter how it is, the law should be explicitly clear enough not to be compared to the spiritual bits of the Ifa oracle consultant, who can only get the message from the divinity, from the gods, exclusively by himself. That cannot be the law in a modern society, in a democratic society. The law should not be for even as much as you and I are lawyers, yes, we interpret, but the law should be so clear that a layman can pick it up and say, this is what the law says. So when you now have the law that says any court of competence, in fact, it is even the way that any court of competence decision. What is court of competence? Do you understand what it is? In fact, in my argument, I said that means it's a possible nothing. It's a possible nonsense. It doesn't mean anything. You see, the only thing that phrase would have made any sense is that if before Section 65 or above it has listed some courts that Federal Court, High Court of State, High Court of State, and it now says any court of competent jurisdiction has listed them. But you cannot know which court is the court of competent jurisdiction, because the subject matter, that donates, that can donate, is not there. So what I have asked the court, some of my reading, that one, the court should declare that provision is unclear. It will lead to chaotic adjudication of disputes on data protection. There will be issues as to precedence, because a magistrate court will give a judgment, and High Court will give a conflicting judgment on another matter. So what do? You'll be relying on the judgment of a magistrate court. And so when it conflicts, you will not, so some things will not be. And if I say, okay, you know what? Let's argue that data protection is an aspect of privacy. Then let data protection be treated as privacy issue. Then can a magistrate court have decision over privacy, which is a fundamental human right? Can it have jurisdiction on it? Can it have it? Somebody talk to me.
Sir.
Yes.
So I have a question to ask you.
Yes, please go ahead.
I agree with all you said. In fact, I didn't know that you were the one that filed that matter. But okay. I've always had this particular thought in my mind.
Okay.
In that act, I went through.
Please, your voice is low. Can you speak up a little bit?
Okay, can you hear me now?
Yes, it's better.
Very clear now, sir, I guess.
Yes.
Okay, sir. So the question I'm trying to, first of all, I want to agree with your position in respect of, the statute not expressly giving, donating powers to a competent court to adjudicate on matters that has to do with data protection. Now, I'm looking at it in another dimension now. Data protection and privacy is an offshoot of, fundamental rights of
yes.
privacy inherent in the Constitution.
Yes.
And matters that has to do with fundamental breach of fundamental rights, the law has given jurisdiction to federal high court or state high court for a person to approach when his right has been breached or is likely to be breached. Now, there are rules of interpretation, which we have the literal rule, the golden rule, and the mischief rule. Now, what if the court decides to, in his, quest to find, a solution to this particular, lacuna in this particular law, decide to reason in a way and say that the competent courts in this particular matter is either the federal or the state high court, since the data protection is an offshoot of the right to privacy in the Constitution. Are you preempting that the judgment of the court will likely go in that direction?
Now, as a matter of fact, in my can you hear me?
Yes, I can hear you, sir.
Yes, sir.
Yeah. So, in fact, as a matter of fact, in my release, one of the things I did is that the court should interpret it to mean that it's any court of competent jurisdiction as used in that provision means federal high court of state, and high court of FCC. Now, I did not just stop there. I now ask the court to issue a specific order for the National Assembly and the AGF to ensure and facilitate amendment of provision of Section 65 to reflect federal high court of state, and high court of FCC. So I know that that is the ideal thing. But let me be clear, sir. It is not like we have all said, a legislation is not meant to be an infer priest bit where we can only infer. You cannot infer. And that's what the court have said, that the subject matter jurisdiction of a court is not what can be inferred. So I'm going to put the question back to you. If the court would just say, I assume I have jurisdiction, would that not amount to inferring? No, please talk to me.
It's definitely will, sir.
Sorry?
I said it's definitely will. It's definitely lead to inferring.
Let me tell you, let me share with you, friends. Now, one of the reasons why litigation is interesting, and litigation is quite will be a bit more difficult than acting as in-house counsel and all of that. Litigation is all about fact. Like I told you, I want the court to say it is federal high court of state, and high court of FCC. Now, but beyond that, I want the National Assembly, the legislature, and the AGF, who is responsible to liaise with the legislature to ensure that that legislation is amended to expressly read that. Now, I will tell you why that is very, very important. As I speak to you today, with all the, as long as we have that position, with all the matters I've had to, when it comes to what is it called? Data, I've always approached only to federal. And you know what I always do? Now, in my process, I always file, either arbitration or the, and I always premise it on Section 37. Are you with me? You see, when you premise it on Section 37, when that makes your foundation, then the issue of whether is it a fundamental rights question, nobody can disagree that way. So that's what I always do. When you do that, then you have cornered everyone. And let me see if I think I have it there. I can see a process. So what I've done is, now I said, in the matter of enforcement of fundamental rights to privacy and guarantee Section 37 of the Constitution of the Federal Republic of Nigeria by Solomon, in the matter of enforcement of right to privacy and protection of personal data as guaranteed under the Nigerian Data Protection Regulation 2019 version. So I now went down and forth my release and all of that. So the way I've argued, I always say structure my argument is to say, one, right to privacy guarantee. Two, right to personal data under NDPR or under NDPR or under NDP is an offshoot of Section 37. And interestingly, there are provisions of, there are decisions of our court that effect. Usually an in the state. Another one, let me see. So, yes, you have DRLI and NIMS. So that is where the court says, my Lord Justice A.B. Mohammed Jesse, but it was an appeal, I argued that court appeal. He said, on the relationship between NDPR 2019, Section 31 Federal Constitution, it is pertinent for me to state that Constitution makes provision guaranteeing the various fundamental rights of citizens. But as stated earlier, the nature and scope of those rights and even their limitations are in most instances furthered by other statutes, regulations, or other legal instruments. It is in this instance that NDPR 2019 must be construed as providing one of such legal instruments that protects or safeguard the right to privacy of citizens as it relates to protection of their personal information or data, which the trial court had already adjourned at page 89 as to the record part of the privacy guaranteed by Section 37. In fact, I have some other, okay, so DRLI versus Minister of Justice, Trade and Investment. My Lord Justice Linda says, all things considered, I hold that the payment of the recorded. Yes?
I'm sorry to butt in, but we are out of time.
Yeah, we're out of time, clearly. Yes.
Yes,
I'm sorry, but actually, I've got quite a number of things for time. I just got carried away. But so, in the research to wrap it, now for me, the strategy has always been, have you right to privacy as your foundation, then place data protection. By that, in that way, you won't have any, even if anybody brings issue of data protection, any issue of protection can't. But we are now saying, for the purpose of a situation where you don't even have to bring this Section 37 of the Constitution. Look at it, for example, freedom of information is an offshoot of Section 39 of the Constitution. But now, when we now have Freedom of Information Act, you don't even have to bring the Section 39 of the Constitution anymore. So let's have a legislation that can fly with its own wings. And that's why we need that law to expressly state to court that action, instead of us just telling us some fancy things by saying any court. At this point, and with this little point, we used to say in those days, I believe I'll be able to convince and not confuse. And for those who are confused, may the Lord provide you some level of clarity. So then, I think it's been a very amazing and warm night from the end by me today. I wish you a beautiful week ahead and a more amazing session. Thank you.
Thank you very much, sir. We really enjoyed your session, sir.
Thank you very much, sir. I hope you get judgment in your case, sir.
Yes, I hope so too. Anyway, if I do not get judgment, you can be sure I'm going to the court of appeal and I will get to go after.
Thank you very much, sir. I hope to get my gift, sir.
I didn't even know you were the one involved in that matter.
Sorry, what did you say?
I didn't even know you're the one involved in that matter.
Well, I didn't know so.
Okay.
Before we conclude, can everyone turn their video, turn on your camera? Is our picture time?
Me, I've kept up my video on. I'm shirtless.
It's okay. If you can, please turn on your video. Let's take a picture, take a screenshot, post it on your social media handles on LinkedIn, on Facebook, on Twitter. Tag JIIPCC, tag our speaker for this session, tag me, tag your friends, tag everybody you can. Preach the gospel of JIIPCC. Now it says cheese. Okay, thanks so much, Mr. Solomon, for this enlightening session. Once again, we are awed by all you have to give us. Thank you for your humor, for your patience. I will look forward to having you once again. It's a turning point for us in our lives where we are no longer data protection enthusiasts, but experts. And we are privileged to have you with us.
Your father. It has been great being with you guys this evening. Have a beautiful evening and amazing weekend. God bless you.
Okay. Thank you everyone for coming for JIIPCC. Hope